Hey y'all, I am the loud little ducky. Today we are going over Laura Owens trying to renew her protective order against Greg Gillespie. We knew that this was coming, that she was going to try this. I think it's not very smart given that everything that has come out about her and Greg has all that information in his corner now to better fight back. Because there's a ruling in court that shows the type of person she is. But let's take a look at this and be prepared for the fraud alert. So here we have filed on January 8th of 2025, Owens v. Gillespie, and says use this form if you are authorized to serve legal papers under a thing, undersigned being first duly qualified by law, swears or certifies that a copy of the following personally arrives to the defendant on January 7th. So this arrived to the defendant before it was even filed in the court. But it says it's a petition and order of protection, so an OP. And the plaintiff has not been advised of service, and the defendant is a peace correction detention officer. Okay, I didn't know that Gillespie. Oh, the declarant. The declarant. My bad. The declarant is a peace correction or detention officer. So I guess the one that's serving him, David Sheets, Maricopa County Sheriff's Office, no fees, and then it talks about a description of Gillespie. All right. Now we have, so that's just the paper showing that, hey, he was served. So then we have trial courts of Arizona and Maricopa County. This was filed as of December 6, 2024. So this is when this was filed. So she filed this back in early December, and then he was served in early January. And so plaintiff Laura Owens, defendant Gregory Gillespie, and alleged weapon use is no, so that's good. No weaponry stuff. Warnings to the defendant. This order shall be enforced even without registration by the courts of any state, the District of Columbia, and any U.S. territory, and may be enforced by tribal lands crossing state lines. To violate this order may result in federal imprisonment because of this order. It may be unlawful for you to process or purchase a firearm, ammunition pursuant to federal law. If you have any questions whether these laws make it illegal for you to possess or purchase a firearm, you should consult an attorney. Only the court in writing can change this order. So Greg cannot go buy any firearms currently. And if he wonders if he is allowed to possess them, he needs to talk to his attorney, apparently. Any order served on or after September 24, 2022 is in effect for 2 years from the date of service. Any orders served before September 24, 2022 is in effect for 1 year from date of service. So I guess September 24, 2022, they decided to make things 2 years instead of 1 year, maybe to cut down people coming back yearly, so they only come back 2 years. It says, this court hereby finds that it has a jurisdiction over the parties and subject matter. It says defendants shall have no contact with the plaintiff except through attorneys, legal process, court hearings, and as checked. So she didn't check any of that stuff. So the only way Gillespie can talk to Laura is through her attorney. But it's interesting because Laura was willing to talk to Greg in the Eckerd case. We'll just sort all this out. She was willing to talk to Mike as well, but like, she'll just talk to these guys. Like, no. Like, you want them to violate the court order. And the thing is, even if she was inviting of it, if Mike or Greg had decided to talk to her and not the attorney, that's a setup for a violation. So she could be like, well, he talked to me. And Mike or Greg could say, well, she wanted to talk. And the court and the judge is going to say, it doesn't matter. You're not allowed to. That's why the whole, oh, I'll talk to my people I'm scared of is such a crazy thing. But it goes on to further say the court further orders protected locations. Defendants shall not go to or near plaintiff or other protected persons, residence, which is confidential. It also checks other. Then it has a protected address. Has nothing to do with firearms, nothing to do with animals. Other orders, no contact included, no contact from third parties or via social media. So don't Facebook message them, don't Twitter message them, do not be up in anybody's DMs or posting stuff to them and tagging them on social media. What via social media means is do not directly contact. That does not mean that you cannot speak about your life or your truth or anything like that. You just cannot reach out to them and contact them. And by Greg talking to anybody about his life is not him reaching out to Owens. He's not sending it to her. He's not doing anything because we don't need to send things to Owens because she just goes and looks for them. But even if she didn't, nobody would be sending her this stuff and saying, hey, the only person that's sending it to her might be her attorney, which is furthering destruction to her mental health. And then this was signed by a judicial offer on December 6, 2024. Warning, this is an official court order. If you disobey the order, you may be arrested and prosecuted for the crime of interfering with judicial proceedings and any other crime you may have committed in disobeying this order. Notice, if you disagree with this order, you have the right to request a hearing, which will be held within 5 to 10 business days after your written request has been filed in the court that issued this order. Violations of this order should be reported to law enforcement agency, not the court. So do not contact the court, Laura. Each party must notify the court if an action for dissolution, which means divorce, separating, annulment, or paternity and maternity is filed. This is not a parenting time, visitation, or custody legal decision-making order. You must file those requests separately in Superior Court. Additional warnings to defendant. Nothing the plaintiff does can stop, change, or undo this order without court's written approval. You must appear in court to ask a judge to change, modify, dismiss, or quash this order. In other words, Laura can't say, oh, I want to talk to you, Greg, without Greg going to the judge and saying, can I talk to her? He's not going to because he wants nothing to do with her. But that's what it means. Just because she's like, oh yeah, you could come over, we could talk, we could get together, you could feel tightness, you could do all these things. But if the judge doesn't say that he can do those things, he can't. And he doesn't want to, so he does not need to go to the judge for permission because he would like her to just go away. Notice to the plaintiff, if this order gives you exclusive use and possession of the residence and you move out while this order is in effect, you must notify the court within 5 days of moving out of the residence. So that one doesn't apply here because they don't live together. The next page is the petition for the order of protection. Defendant and plaintiff's relationship. It's romantic or sexual relationship, past or present. So that's the one she checks. Tell the judge what happened and why you need this order. Print both the dates and a brief description of what happened. If there is a contested hearing, a judge can consider only what you write here. And defendant will receive a copy of this, which I know Owens sometimes likes to do things where people don't receive copies and wants to be ex parte. I know the writing is very small, but we are going to read through all of it. And hopefully you can turn on closed captioning if you need to. September 27, 2023. On September 28th, 2023, why are you going to put 27th and then you're going to say the 28th right next to it? Okay, your lies already started. A Reddit user under the handle blank posted an order of protection against me, one that Greg Gillespie obtained in August 2021. Just a day after I filed a civil lawsuit against him for abortion coercion. This order was never served, meaning it was never legally in effect. It doesn't matter if it was in effect. He can say, I tried to file this lawsuit against her. Like, he has the right to say, look, I did try to serve her. It didn't work. This is what I tried to serve her with because this is my side of the story. He's allowed to do that. One that according to Manny Vargas, the clerk at Dreamy Draw Justice Court, only Greg would have had access to this unserved document, not even I, as the named party could have obtained it directly. Manny confirmed in a recording phone call on October 3rd, 2023, that Greg had not only picked up a paper copy of this order in person, but also had requested that it be emailed to him. This timeline is sufficient because the post appeared on Reddit the same day that Greg collected the document from the court, demonstrating a clear chain of events. Greg's own admission to the police that he had collected the document aligns directly with the Reddit post appearing shortly thereafter, indicating he was either directly involved or indirectly facilitated its leaks. This action, retrieving the document, then either posting it himself or allowing it to be posted publicly, is not an isolated incident, but a part of a broader pattern of harassment, where while Greg continually seeks ways to harm my reputation and cause me distress. By ensuring that the document was posted online, he engaged in conduct that was unquestionably intended to intimidate, embarrass, and harm my standing. Lady, you've done that on your own. This act runs counter to the no crimes and no contact clauses in the order, as it is clear, an attempt to circumvent direct communication while still causing reputational harm. The truth is a defense to things, and he did not directly send it to you. I think that posting it on social media should have been a way to service, because we will probably be seeing that as a method of serving people in the future, is posting it to social media and tagging them, or doing an email and read receipt. Like, there's going to be online service probably more frequently in the future than in-person service. They're just going to have to work out the issues of, did the actual person get it, or can they say, oh, I never received it, my husband or kids opened that and I never saw it. Like, so they're going to have to work out that, but I can see it being a thing. It's not a crime to tell your side of the story, and he also did not directly contact you. So I don't feel like he violated his order. I'm not the judge in this case. I'm hoping it's not Judge Duty, and if it is, maybe his eyes have been opened due to the other court case, if he knows anything about it. So furthermore, the nature of this act, distributing a document he knew was unserved and therefore invalid, suggest an intent to mislead and malign, aligning with pattern of indirect harassment meant to disrupt my life. Just because it's not served does not mean he can't say, yeah, she filed this on me and I tried to file one on her for these crazy things, but she never allowed herself to be served. Like, he can defend himself in the public. 2 years later, he's just talking about it. Or 1 year later, whatever it is. So then we have the next incident that she says, and this is November 5th, 2024. On October 6, 2023, I obtained an order of protection against Clayton Eckerd. She lists the case number. Just weeks later, on November 2nd, Mr. Eckerd obtained an injunction against harassment against me. So finally, somebody gets one against you. And they're going to be able to look at that and maybe see a pattern and be like, well, you've done this in other cases, so yeah. During the pre-issuance continuance hearing for this injunction, Mr. Gillespie attended the court session, ostensibly to support, air quotes, Clayton, a man he had no prior relationship, until I filed a paternity case against Mr. Eckerd. Yeah, because now they have something that bonded them, because they are both victims of you, even though you try to spin it the other way. Gillespie's presence was undeniably strategic. He appeared there with no legitimate reason, clearly expecting I would be present, hoping his appearance would shock and unsettle me. No, he didn't. And you know why? Because there was a document that was a public filing that said you were not physically going to be there. He had absolutely no connection to the case and was not a witness or an involved party, which makes his attendance purely and simple an attempt to intimidate me. This behavior is clear violation of the order of protection I hold against him, as it constitutes an intentional act of confront or intimidate me. His actions reflect a blatant disregard for the terms of the order, as he appeared at a place he anticipated I would be, solely to cause distress, although I was able to attend virtually due to the last-minute decision by the judge on the morning of the hearing. It is evident that Gillespie presumed he would encounter me there. No, because Eckerd or Woodnick could have talked to Greg and said, hey, she's not going to be there in person. She's appearing virtually. He knew you had an order already stating you wanted to appear virtually, and that it got approved. So he could have known you were not physically going to be there. Therefore, he would not be violating the order. Because we don't know if he would have showed up to a hearing that you were physically in person at. And I don't know if he actually ever went to a hearing where she was in person at because of the order. He went to that one because she was virtual. Now we go to another incident on July 25th, 2024. As part of his ongoing harassment, Greg Gillespie has publicly leaked private emails, text messages, and alleged recorded phone calls. These private communications have been featured in YouTube videos by content creators such as Dave Neal and Dr. Hines, where they are used to scrutinize and disparage me. Gillespie's decision to release personal conversations publicly is a clear violation of the protective order. The order explicitly prohibits direct or indirect contact and any behavior that could reasonably cause harassment or distress. Just because your lies are being brought out does not mean that is not the distress they're talking about. Like, oh my God, I'm going to get caught. This is causing me so much stress right now. Like, how could he tell the truth on me? This is causing chaos in my life. That's your issue. He's not doing that to you. Because if you were telling the truth, it wouldn't distress you so much. By ensuring that my private interactions are broadcast to a wide audience, Gillespie is clearly using these leaks as a means to intimidate, embarrass, and provoke emotional harm. This is indirect harassment designed to discredit me and cause ongoing distress. And it clearly disregards the protective order terms which were put in place to prevent precisely this kind of intimidation. Telling the truth is not intimidating. Maybe to you because you lie all the time. Gillespie's repeated and public exposure of my private communications reveals a clear intent to harm and manipulate my reputation, turning what should be protected private exchanges into tools for harassment. His actions demonstrate a blatant disregard for the orders proposed of safeguarding my privacy and well-being. Also, are these private conversations in public documents? Because I believe those are the conversations most of us have covered. I'm not for certain, but I'm pretty sure that everything that we have covered has been publicly available in court documents. But I could be wrong. Don't quote me on it. Blatant disregard for privacy and well-being. No. So sorry. My allergies are killing me today. January 10th, 2024. Gillespie has made public statements on his Instagram account under the username blank. Stop looking for his Instagram. He has you blocked. So stop seeking it because he's not seeking you. In one particularly alarming post, he wrote, "Stop this woman. No one should cave to her harassment. She is dangerous." Yeah, that's a public opinion. He's allowed to say that. This statement publicly labeling me as dangerous and accusing me of harassment serves no purpose other than to harm my reputation and incite fear and distrust among those who see it. But he didn't contact you directly. And he doesn't need to harm your reputation. You've done that. But by publicly characterizing me in this way, Gillespie is actively attempting to influence others' perception and creating hostile environment for me. No, because people's perception of you has nothing to do with Gillespie's Instagram. You've done that in the court system and your court hearings and your filings. You've done that. Such language calling me dangerous and accusing me of harassment is intended to provoke others to act against me, effectively encouraging third parties to stop me. Now, we don't need him to tell us to stop you. We do that on our own. This kind of inflammatory statement, you can say it's inflammatory, but there's proof that it's not. Goes beyond personal opinion or commentary. No, it doesn't. It's a calculated effort to portray me as a threat, encouraging others to engage in or support this campaign of harassment. By spreading false and harmful narratives about me on public platforms. He's not doing that. Gillespie is engaging in a form of indirect harassment, using his social media presence to harm my reputation and provoke fear. He has not threatened you. So I don't know why you're in fear. This post illustrates a continued pattern of intimidation, as Gillespie is not merely airing grievances, but actively attempting to harm my standing in the community and incite further hostility. Ma'am, you have destroyed your standing in the community with your lies and things that you've done. He has not done that. You did that on your own. He's just telling the truth and talking about what happened. His actions represent a blatant disregard for the protective order, which is meant to prevent precisely these types of aggressions, public displays intended to intimidate and cause emotional harm. If this is what protection orders say, so if this gets granted, the courts are saying that if somebody falsely accuses you of something and you speak your truth about it and you defend yourself, by still not contacting them, you're just putting your story out on your social media or wherever, talking about your experience. And the courts are saying that you're not allowed to defend yourself or put out your side of the story. You're not allowed to speak your truth. What the hell are we doing? Because that is not what this means. These protection orders are in place to keep people alive. That is the purpose of a protective order. To not cause danger. Just because you are an emotional basket case and you cannot handle being called out on your horrid actions does not mean that there is a violation of a protective order. And if this gets granted, it is saying someone falsely accuses you, you can do nothing about it. You cannot defend yourself to the public. You cannot clear your name and put out factual information. And I really hope the courts are not going to be sending that message. Because that lets these con artists get away with more and to continue abusing the court system to their favor when they're the ones that are misusing it and deserve to be in jail for the stuff that they have done. This pisses me right the fuck off. This is absolute nonsense. And I hope that Greg is heard in this hearing. And that the judge is no longer just blinded by a mere tiny little girl who, what could she do to anybody? I physically can't hurt anybody. I'm under 100 pounds. Like, I couldn't hurt a fly. He's tall and big. Thing is, many women do not harm men in a physical way. There are some that do. Women will move in the shadows. They are calculated. They will move in the shadows and then strike. And it's not going to be in a physical way that leaves a bruise or a mark. That is how most women operate. Some of us can be fine and dandy, like I'm fine and dandy and great. But if you wanted to play dirty and you wanted to try to do things in this type of way, trust me, I would be moving in the shadows. Let's continue on, because that just... You have caused yourself emotional distress and harm, and you're only intimidated because you don't like being called out. August 4th, 2024. On August 4th, 2024, I received an email from blank informing me that a woman named blank of blank, an associate of content creator Dave Neal, had obtained intel about me directly from Greg Gillespie. Oh my God, Greg Gillespie talked to somebody that wasn't you? Please tell me how that breaks the protection order. Oh my God, Greg, did you know that according to Owens, you're not allowed to talk to anybody? You're not even allowed to say her name. Like, apparently that's breaking a protective order. You talked to somebody and said my name. Oh my God, you're going to jail. That's what Owens thinks in her mind. According to the email, this information was shared with the assistant of a woman named blank of blank and was specifically intended to harm my reputation through wider dissemination. This demonstrates that Greg Gillespie has actively collaborated with others to share private or harmful information about me, with the apparent goal of exasperating the distress and damage caused by his actions. No, this shit is caused by your actions. Gillespie's actions are not protected speech under First Amendment, as they serve no legitimate public interest and are expressly intended to cause harm, contrary to the restrictions of the protective order. See, that's where you're wrong. Because when this case and all the men that you've claimed you were pregnant with, this became a public interest story. It was public interest on like YouTube and stuff. And then even news places picked it up. The Sun picked it up. It was picked up. You made it a public case, and therefore all of the people that have watched these videos, the millions of views, if you calculate everybody's views on all the videos that have covered this case and all the men involved, that's going to equal public interest. And so therefore, he can speak about it because he was involved in the case. He's allowed to do interviews and say things. He just is. And you can sit here and say, oh, this isn't public interest. Then why is the public covering it? You're wrong. She says the order prohibits not only direct contact, but also indirect actions reasonably expected to cause distress, harassment, or harm. By enlisting third parties to disseminate private information with the intent to discredit and intimidate me, we're allowed to discredit you. I'm sorry that you don't like that, but he's allowed to discredit you and your story. Gillespie is actively circumventing the court's restrictions. This calculated effort reflects a clear and ongoing disregard for the boundaries set by the court. The involvement of a third party in these actions exasperates harm or creates a wider circle of hostility. This is not lawful. Expression but targeted harassment intend to intimidate and cause reputational damage, violating the protective order. Gillespie's behavior is a direct attempt to use others to achieve what he is forbidden to do himself, further demonstrating his intent to undermine the legal protections afforded to me. No, that's not what has happened. Like, you live in a Delulu world that you've created in your head that you know is not reality, but you need to tell yourself that this is what things mean. You're playing dumb. February 2nd, or February 22nd, 2024. On February 22nd, 2024, Greg Gillespie attended a court hearing related to my paternity case with Clayton Eckerd. Gillespie had no legitimate involvement in the case or reason to present in the courtroom. According to the article published by the Arizona Republic on the same date, Gillespie attended the hearing as an observer and declined an interview afterwards. His presence at this let me see here. His presence at this sensitive proceeding was clearly intended to intimidate and distress me, knowing that his attendance would cause discomfort and emotional harm. At the time of this hearing, Gillespie was not listed as a witness in any capacity. This designation only occurred later on March 29, 2024. His attendance on February 22nd had no connection to any legitimate legal obligation and was solely an act of harassment. This behavior directly violates the protective order, which prohibits indirect harassment and any actions reasonably expected to cause me distress. That one I'm going to have to look a little bit into, because if he didn't have that particular one, everything else here is bad. Like for Laura, everything she listed is not a violation, in my opinion. This one, I have to look at the details on it, and then I will post that later in the video on what I find so that we have clarity on that. But we'll have to see. So then we have December 28th, 2023. I have 2 orders of protections against Gillespie. One served on November 15th, 2021, that was in effect for 1 year, and one that was served on December 8th, 2022, that was in effect for 2 years. Okay. And now she's renewing this third one. I don't think any of those should have been granted, but so those are her dates. Notice June 10th was not on there. But yet she wants to try to get Mike for the June 10th one. When even though she tried to make a police report, but the police report on that one says there was no violation. Anyways, so it says the following persons should be on this order. This should be protected because defendant is in danger to themselves. Defendant should be ordered to stay away from these locations at all times, even when I am not present. Residence, school, or other. Didn't realize she was, I mean, I guess she's not in school. I don't know what other is, but they have the addresses confidentially. Defendant should be ordered not to possess firearms while this order is in effect because of the risk to harm me or other persons. So she wants Greg not to be able to own guns. For what reason, I have no idea, because he's not going to be using them on her. He never has, never will. Defendant should be ordered to stay away from any animal that is owned, possessed, leased, kept, or held by me. Defendant or a minor child living in either my household or defendants. So Greg needs to stay away from animals that Owens owns. Other requests: no indirect contact through third parties or online forums. Prohibit him from sharing police reports or court filings related to me. Those are public documents. You cannot tell somebody they are not allowed to post those. And if somebody else goes and looks them up and he doesn't post them, they're public documents. Anybody can get them. That is not going to be allowed. Even if she does get this, if she gets this approved, that is not going to be a thing. Ban on sharing my personal information. He doesn't share your personal information. No interaction with my online profiles. He doesn't contact you online. You do all the stuff. You go and view his stuff. He doesn't go and view you. No surveillance or tracking. He doesn't do that. No mentions of me in harassment forums. So you can't use my name. So Greg, she wants him to not be able to go on the Justice for Clayton or Justice for All Laura Owens Victims pages, Victims of Laura Owens pages, none of that. That he cannot go on there and even say her name. Which is total BS. You cannot limit somebody like that. Because why? One, stay out of the harassment forums and you wouldn't even know about it. You're the one doing all this. You are the one causing stress in your own life. Step away from the internet and you will be much happier. It's insane. And then, of course, under penalty of perjury, I swear or affirm the above statements are true to the best of my knowledge. And I request an order/injunction granting relief as allowed by law. Signed, Laura Owens and somebody with the judicial on December 6, 2024. So there we have it. That is her trying to get another protective order against Greg Gillespie. And a bunch of it is nonsense. People are talking about me in a public case that also involves Greg Gillespie's public case now because she's tied to all these things. Nobody would even know who you were if you would stop striking and going after so many men. Over 10 years of this BS by now, as of now, that we know about. From 2014 to the present. And she just wants to keep going. But I guess if you've done something for 10 years, it's really hard to break a habit. But therapy would help. Okay. So I reviewed the February 21st, not 22nd, hearing that Greg Gillespie attended and Laura Owens was at. Corey Keith was Owens' attorney at this time. This is the one where she needed to sign the HIPAA releases in front of the judge. This is the hearing where she is claiming no longer pregnant and that she went to an appointment in mid-November and found out she was no longer pregnant, but they think it happened several months prior. This is the hearing where they ask the judge to take notice of the injunction against harassment hearing where Owens was on the video rubbing her pregnant belly and claiming she was 24 weeks and 100% pregnant still, which was before her doctor's appointment where she found out due to a negative pregnancy test she was no longer pregnant. And then so this was a huge important hearing. Greg Gillespie was in attendance, I believe, with his wife or fiance that was at. They were talking about getting medical records as far back as 2018, and the judge allowed 2020, I believe. Which would include Greg Gillespie's medical records of places she had been as well. I don't know if they were going to use him as a witness, if need be, to talk about records and patterns of why they need it as far back as they did because of Gillespie. As far as I know, there was nothing in court filings saying, hey, we're going to call him or he's going to be at this hearing. So that is the only one that is a possible statement by Owens that he was at that hearing. Now, he was not at that hearing to intimidate, embarrass, harass, or anything to her. He did not speak with her. He was just there supporting Clayton. And so that was 2024. And she had the protection order from December 2022 that was in effect for 2 years. So at this time, the thing is that if you go from December 8th, 2022 to, well, no, it was still been in effect till December 8th, 2024. Okay, so never mind on that. I was going to say maybe it wasn't in effect then, but it still was in effect at that point. So that part's going to be interesting. Greg will have to defend that. He does have Woodnick that he had, that he'd been talking to during this time. I don't know if Woodnick is going to be representing him in this matter or not. Haven't seen anything on that. But it was part of a legal case. So that was the only one. So he did attend. The reason he attended is not why Owens says it. Owens did not ask the court to make him leave because she was scared. She did not file a motion in regards to Gillespie being there before or after. She did not file a motion talking about Gillespie attending the hearing where she was virtual. She did not make a police report for a violation of this at the virtual hearing or this February hearing, to my knowledge. Granted, you don't necessarily have to. You can, I guess, wait to reserve all that when you go to renew. But she didn't report these violations, which to me says she wasn't scared because she was not focused on Gillespie. She put out Medium articles and things like that. So that's the only one that Greg is probably really, really going to have to defend himself on. But does that, with all the lies, is that one going to be enough for a PPO? We will see. We will see what happens in this case. I'm now wishing that Gillespie didn't show up to any of them, even though it was great of him to support Clayton. But now that could be a huge problem for him, even though he didn't do anything to her. So stay tuned for more updates on this shenanigan as it goes on by subscribing and hitting that like button. But ending our Owens videos with a quote of the day is, if you tell the truth, it becomes a part of your past. If you lie, it becomes a part of your future. And I think that's true in this case. You just tell the truth. It's in the past. Nobody says anything. You don't have to worry about it. Whatever. But if you lie, like in Owen's situation, her lies that she has been telling since 2014 are now still a part of her life in 2025. In the future. Her lies are still a part of her everyday life and will continue to affect her in the future because it has messed her credibility up. It has killed her reputation. And if she would have just told the truth, none of this would be going on and there would be no future endeavors about this. So just tell the truth. That's it. Then everything is done. You don't have to keep up with your lies. You don't have to remember them because it's hard to remember things you said 10 years ago. I mean, it's hard for us to remember things we said yesterday or this morning. And then I heard another one, and it was in the Karen Reed case, but if a lie goes unchecked, it then becomes the truth. And that's what Owens has been gliding on. Is she has said all these lies and they have not been checked. They have gone unchecked. Her lies have gone unchecked until Clayton. And so her lies were basically the truth in the world. These poor men, because everything was unchecked and people just blindly believed, Owens got to sit here and speak these lies as if they were truth. But now she's been checked. She's had a hard reality check. Has it changed her behavior? Absolutely not. She doubles down. Her lawyer doubles down while exposing more lies of hers while trying to double down and make her seem like she's telling the truth. It makes no sense. The truth is always going to be on your side. So don't lie. That's where your distress comes from, is that all your lies have become a part of your present and are going to be a part of your future. When if you would have just told the truth and let these men just live, you would be fine. You could maybe have found happiness. But now you have a label on you, and a public label. But you reap what you sow. So make sure we're telling the truth out there, sticking to facts, and I will see you next time. Bye.